Good evening and thanks for joining us. This is Bar Talk. Tonight we're going to be talking about keeping marital property separate and the relationships of fiduciaries with powers of attorney and agency. So with that, let's get started. Hi ladies, how are you tonight?
Hi, great. Nice to see you.
Yeah, good to see you guys.
Nice to see you as well. So Dana, powers of attorney and fiduciary relationships. Talk to me a little bit about that.
I was thinking about an issue that comes up in my office is that people come in to prepare their estate plans, and so we have a consultation and we talk about it, and we get to the part in the consultation where I ask, so have you thought about who you would like to name as an agent to help you with financial decisions or healthcare decisions in the event you're unable to? And many times people have thought about it and they do have an agent to name, but it happens more often than you might expect. People say, you know, I really don't have anybody. Mm-hmm. And
what do you do in that situation?
What do you do?
Yeah.
So that's my question. What do you think you would do if you don't have anyone to name?
I mean, the first thing that comes to my mind is you kind of just pick someone that maybe wouldn't be your first choice, but someone is better than no one. But
right.
I don't know if that's true.
So let me pose this to you, because these clients will come in and they'll say, no, I really don't have anybody. I don't have a spouse. I never had any children. My family has all passed away. I don't have any friends. What do you recommend? And you do get into a tough spot, because those are all of the obvious places that you think of to go to, but it led me to think, where would I go? And where do you think?
My thought is a neighbor, maybe someone down the street who you've known for a long time and that you trust. You might not be that close to, but you might trust their decision-making abilities.
Yeah, but you know, in our communities nowadays, we are often, our communities are no longer those where people are outside and communicating. I mean, everyone they're busy, they have their own lives, they are, people don't know each other like they used to in their communities. People don't even stay in their communities as long as they do. So I have clients who say, I don't know my neighbors.
Well, but if you're going to talk to a person who comes in and says, I have no friends, I have no family, first of all, you have to explain to them why an estate plan is necessary for somebody who has no friends and no family. Because if they pass away and have no interest to go to somebody, or decisions are going to have to be made for them if they're sick or unable to make decisions, you first of all have to explain what could happen. And then you can maybe help them say, well, who do you trust? Do you have a pastor? Do you have a neighbor? And if they say, if I do powers of attorney for healthcare and for property, and so if a client came to me with that question, I would say, if the response to me was, I have no friends, my answer is make a friend. Because in order to have someone step in your shoes as a power of attorney and make decisions for you, they ought to be able to advance your interests in doing so. And if you're friendless, there's either a reason for that, or that's by some choice. There's some issue that has caused you to be friendless and alone. But you have to pick.
You're not judging people for not having friends, are you?
No, absolutely. But what I'm saying is if you're going to do a power of attorney, you need to pick somebody.
Regardless of that situation, it's an important decision. When you name an agent, you're naming someone to have access to your funds in order to step into your shoes and handle affairs. So to just go make a friend for this purpose, I mean, this really isn't resolving the problem.
But the average client doesn't have 0 friends and 0 family and 0 contacts. So if you're talking about an outlier situation where that client, as you've posed the question, comes up, they've got to, if they're going to have a power of attorney, they've got to do something. So they have to find somebody that they trust. There is somebody there, maybe they haven't thought of it. So as a lawyer, what I would do is help.
Don't have anybody. Well, what would you do then? That's kind of what the issue is. Let's say there is nobody. I've had the case in front of me several times. What do you do when there is nobody that you know that you could trust, or that's even willing?
Well, one thing that Elisa brought up is the issue of risk, right? So if we don't appoint anyone, is it possible that the government will appoint someone for us? I mean, is this something that would happen where the judiciary would just decide, or the hospital administration would have a say in what happens?
A guardian would be appointed.
Yeah, you wouldn't be able to have someone named as a power of agent under a power of attorney by the state, but you would be able to go through guardianship proceedings, and that is in fact oftentimes what has to happen. And guardianship proceedings are complicated and costly. So when people come in looking for an estate plan, and powers of attorney are a critical part of a complete estate plan, then if you don't have a fiduciary, one consideration I've thought of is there are what is known as a professional trustee. So sometimes people their job is to become an agent. So they
Right.
will be your fiduciary for a fee. You can name them. They've been in, you can check out their
Banks
business.
do that. I mean, yeah, I was going to suggest the same thing.
Oftentimes banks are corporate fiduciaries. Now banks are a little questionable because they usually don't want to step in as fiduciary unless there is enough of an estate.
Right.
But we do have some individuals who work in this area. We do have some individuals who work as personal private fiduciaries for a more reasonable rate. So
And
that,
how would you find those people? I mean, is there a list of them somewhere?
yeah, well, I mean, Google is a great, resource,
Right.
but a lot of people still don't use the computer, or maybe they wouldn't know how to find them. So probably talking to an attorney, or maybe asking your friends if they've heard, or your church
Right.
group, or whoever it is that you talk to, you can ask, have you ever heard of this service?
Right.
Where an individual will be a personal fiduciary.
So we have to go to break. So before we go, would you say that the most important thing in terms of an estate plan or thinking for the future is trying to consider somebody in your life that could be important enough to help you make decisions in the event that you can't?
Well, that's definitely an important consideration.
All right, thanks so much, Dana. We've got to go to break, but we'll be back in just a few minutes. Thank you. Welcome back. Thanks for joining us again. If you missed us before the break, we're going to talk with Ish about keeping marital property separate from spouse to spouse. So Ish, talk to me about this and explain to me what you mean by the concept of separate property being separate.
Well, a lot of people wonder, what if I suddenly have this huge windfall? I get an inheritance from my grandmother who just passed away. I mean, does my spouse get a piece of that? And what if I don't want them to? What if I want to keep this as my own separate property? So I was thinking about a way to explain this issue. A lot of people are confused about what stays separate when you get married, especially if this is separate property that you had prior to the marriage, or perhaps it was a large gift that you inherited during the marriage.
Well, that leads me to just an initial quick question. Is there a difference between a gift versus an inheritance in relation to that situation or that question that you're asking?
There is not. For example,
Okay.
at Christmas time, I'll share a personal story. My husband and I received a gift from my father-in-law. It was on the outside of the package. It said both of our names, and it was actually a check for a very nice amount of money.
Yeah, good for you.
I was very grateful. However, this is the important piece. It only had my husband's name on the check.
Ooh.
That is not so great, especially if my husband then deposits that in a bank account that is only in his name, that he reserves for separate property. And this brings me back to what I wanted to talk about.
So he takes it out of the marriage.
It was never in the marriage. One could argue it was gifted to him as an individual, and if he keeps that separate, he will continue to own it as his separate property, even though it was granted to him during the course of the marriage.
Well, this issue comes up also all the time across my desk, where people are creating their estate plans and they want to gift something, or they want to bequest something to their child who is married, but they want to make sure that their in-law, daughter or son-in-law, does not have any rights to that inheritance for their child. And does that fall along the same?
That's exactly right.
Okay.
And here's my little analogy. I know we've talked about having kids and toddlers, so we're going to keep this real simple. Imagine that you're learning how to paint, right? We've got the red paint, which is mine. You've got a can of blue paint, which belongs to your spouse or the other person. And you have some purple. As everyone knows, red and blue makes purple, right?
Yeah, okay. I'm
So
following
we've got
you.
our separate property, and the marital property is going to be our purple can of paint today, all right? So the issue is, if you are red and someone gives you something and you want to keep it red, do not mix it with the other colors.
But in the painting analogy, if we have 3 cans of paint, if we know as a first principle that red plus blue makes purple, do you need that purple can of paint?
Oh yeah, so take for example, I received a large sum of money from a family member, maybe let's just say $100,000, and this is going to be a down payment on my marital property. I can choose to contribute that to the marital property, and as soon as I use that money to buy a house in both of our names, that property that was separate suddenly becomes marital.
Gifted to the marriage.
Exactly.
Okay.
I poured that blue can of paint right into the purple one. It's gone. It's not mine anymore.
Right, okay.
And what you can't do then is 50 years down the line when you're getting a divorce, say, hey, I want my $100,000 back.
Could
That
you,
was mine.
okay, so as a real estate attorney, I get this question, to coin your phrase, across my desk. If the person who received the money got decided to use it for a down payment, but they deeded the property as tenants in common, so that the person who made the $100,000 down payment had, say it's a $200,000 house and they're paying for 50% of it, and she wants to own it 50% hers. Does that then still gift it to the marriage if it's the marital home? Even
Are
though
they married?
They're married, but if they own it separately, not as tenants, not as
Doesn't
joint
matter.
tenants.
Under Illinois law, there's a presumption that it would be marital property.
But isn't that rebuttable?
Well, I think you're gonna have a hard time proving that unless there's a prenup involved, and I think
Okay.
that would be a perfect example where the parties need to spell out what their intentions are. Because what people don't understand is that even if I have this inherited property or a pile of money that I want
Right.
to keep separate, if I use my
Individual
my
money or
paycheck
right.
that I get from my employment and I deposit it into that same account, it's not separate anymore. I've commingled it,
Right.
I've made it marital, and there's nothing you can do about
But if you
that.
get that paycheck deposited in a personal account that your spouse has never had access to, that's personal until you use it for a joint expense?
Nope, it's marital because it was earned during the marriage.
Okay,
I
so
see.
this is
Okay.
this is where the line starts to get a little blurry for me. So in the context of inheriting property, and you inherit it in your name, and you attempt to keep it separate. Let's say it's a piece of land that is improved with a rental, and it's gifted to one part of the couple, and that person receives rent from that house. So are you saying that the rent would be considered marital property because it's earned during the marriage, but the real estate itself would be considered separate property?
I think that's a really simplified way of understanding it, but in general, yes, you're right. And a lot of it will hinge on what actions the parties take. What do you do with that rent money? Do you deposit it into the joint account? Do you keep it separate? What do you do in the event of a divorce? Are you trying to keep the land and argue that, the improvements to the land are yours and not contributed by the events you took during the marriage? It gets really complicated. This is what divorce lawyers spend a lot of time working on. So the bottom line is keep it separate. If you want to keep it separate, when you get divorced, keep it separate the entire length of the marriage.
Way. We'll be right back. Thanks for joining us. Welcome back. We're on Hot Topics. Tonight we're going to talk about entrapment, criminal law, and how the CIA and FBI get involved, maybe a little too closely, in the terrorism connection. So ladies, what do you think about the concept of entrapment and how the government can trick or entice people who are potentially predisposed to criminal activity in creating or joining in a criminal enterprise? Have you heard anything about it?
Are you talking about luring someone into doing something that would be illegal activity?
Kind of. So in some recent news stories I heard on NPR, and The Guardian has done a piece on this recently, there are issues with terrorism activity, and the FBI has set up websites that look like ISIS websites, recruitment, follow us, religiously motivated things that go against the United States government. And these have been created by the federal government for purposes of attracting, like insects, the criminal elements of society that are or may be predisposed to ISIS or terrorist links. And so
like a little bait trap.
a little bit of a bait trap, but you can't necessarily bait somebody unless they're willing to or predisposed to certain activities.
And you're telling me that makes it right?
I'm not giving an opinion on whether it makes it right. It's happening. And so I was reading in The Guardian, I brought this article for us to talk about, and it relates to how the government has a closer involvement in criminal plots than maybe in terrorist plots than maybe the U.S. public realizes, and that relates to the issue of entrapment. So my question is, if we have a situation where the public good is at risk, such as it is with the global concept of terrorism and ISIS and Al-Qaeda and things like that, should the government, the United States federal government, be allowed to create a web that entices or invites people to give it some attention and thereby snap like the fly trap if a line is crossed where there has been some illegal conduct. What do you think
one of
about the
my-
government
one
involvement?
of my questions is, what would your defense be, right? So let's say this happened, and let's say I walked right into it, and all of a sudden I'm doing something that I completely regret later. Can I say, hey, this wasn't even a real situation. This was completely fabricated. This is not real life. Why should I have real life consequences for my actions?
That's a good question, and I think that's a really popular defense. The defense to a claim against an entrapment is itself entrapment, or I should say a defense to the crime, say terrorist or treason or whatever the charge might be, fraud or whatever the government comes up with in an indictment. You would say to your criminal attorney, well, this wasn't a real situation. I was trapped. I'm not otherwise predisposed to having any type of criminal activity. I have no record. This was a complete setup. Right. And then the government comes back and says, well, possible, but you took these steps, you answered this website, you came to this meeting, you told us you were interested in ISIS or, you know, this robbery, and then you took these several steps. We've been monitoring you for all this time. And so we created the avenue, but you got on it willingly and drove the car and you went with it. So there is a fine line, and that's where these cases are coming from. So, you know, do you guys have an opinion on whether, just generally speaking, whether it's legal for the government to create a situation or an opportunity for a would-be criminal to cross that line for the purpose of global terrorism prevention and crime prevention?
Well, I mean, you raise an interesting point where, you know, if we look at the big picture reality, I mean, people who are inclined to take those many steps in that particular direction probably would do so otherwise.
Absolutely.
And so I understand the idea. The question is, you know, does the end justify the means, right? I mean, even if we want to discourage people from partaking in such activity, even if we want to catch people who are motivated to take such action, is this really the right way to do it? Is this the only way that we have to do it?
Well, and I think that begs the question of whether it is the only way. So when you have a situation such as terrorism prevention, the government obviously has a lot of resources to try to figure out and to deal with those things. And terrorism and crimes against our nation and our national security take so many different forms. So I think that's a lot of the generalized thought, is that the government says, well, it's more than one way to skin the cat, so we're going to try to approach this from multiple angles so that we can catch multiple opportunities for crime prevention for our national security. So it's, you know, there's a lot of media attention encircling this issue as of late because of the increased threats by ISIS and Al-Qaeda and international outlets that relate to plots of which are started or are encouraged through the internet. So, I mean, I know, for example, in kind of a completely different realm, where I grew up in Arizona, famous Sheriff Joe Arpaio, in order to catch child support, deadbeat dads, they would have a lottery. They would send out a notice to all of the deadbeat dads and say, well, you've won the lottery, come and claim your prize. And then they showed up and they're like, I got my ticket. And they're like, bam, see you later, because they fell for it. So, so in that case, it's not necessarily entrapment because they're not inducing them to commit a crime. In that scenario, the crime was already committed. They didn't do the thing they were supposed to do.
I mean,
but they still trick them.
Right. Let's take it out of an entirely different context. Let's say there was a group of alcoholics and you knew they had a problem with drinking, and you go and you put a bottle of beer in front of all of them and you say, why don't you drink this and then give me a ride home? Right? Or maybe one bottle isn't a good analogy.
Right.
Maybe it's 3 or 4 or 5.
Right.
But the idea is, are you tempting people to act in a way that they normally wouldn't without the object of temptation in front of them?
But that's exactly the dividing line, is that an alcoholic, you can't say normally wouldn't. Whereas you could, if you take, I think by and large, an alcoholic is predisposed to abusing alcohol and potentially has made bad decisions in the past that relate to drunk driving. So, you know, the example can be so varied and take us in so many different directions, it's hard to say. It's a matter of ethics. Right. Ethics versus law versus what's good for the greater community. So I think
it makes me wonder, like, what's wrong with the more traditional methods of just observing the websites that already exist, of going undercover into meetings that are already taking place without creating fake ones to lure people in?
Well, I think in the terrorism connection, there was the gentleman's name is Martin. I don't remember his last name, but there was this a CNN documentary about a CIA operative that infiltrated Al-Qaeda, and he did so for years. But in order to be credible in Al-Qaeda, you have to go out and do something. So, I mean, you don't just put on the garb and say certain things and all of a sudden you're in the club. You have to demonstrate on a day-to-day basis an absolute conviction to the greater kind of club membership or mission. And so as a result, I think that is widely used, and we have operatives all over the world that are infiltrating. But to the degree that it isn't as simple, it relates to the fact that there are risks involved. And, you know.
And so do you think entrapment is a viable defense?
Do I think it's a viable defense? No. My opinion would be that if you, as it relates to terrorism and terrorism activity for purposes of our discussion, if a person is going to access that type of material and then take extra steps like attending a meeting, having discussions, I think the appearance of impropriety is so far past the line that you're interested in that type of activity that it invites government scrutiny, and therefore the argument could be made that you have a criminal enterprise going on. I think that usually these things involve more surveillance, and there's proof. Every case has proof. But yeah, I mean, if you go to the library and check out certain books, an FBI profile can or may be created.
I think that there's a problem with that. I want to be able to read what I find interesting without people thinking it means something.
It doesn't, well, I agree with you, but at the same time, if it's one thing to go to the library and say, I'd like to learn about ISIS, and it's another thing to go to the library and then go on the internet and then make some calls and then attend a meeting. There's a line, and where that line is going to be case specific, but if you dedicate a significant portion of your life to ISIS-related activities, I think that on U.S. soil, or U.S. radar, wherever Big Brother's watching, I think that you're inviting some scrutiny. And you ought to be prepared to defend yourself and say, well, I just find this interesting. So I think,
I hear what you're
yeah,
saying.
I mean, it's a little scary. But if we're talking just about ISIS, which most average people can agree is super scary, super, you know, they've got some issues with entitlement. They've got issues of political opinion, religious conviction that go well against normal religions and government protocols. You know, all bets are off because we're talking about our safety.
Good to be aware of, and I hope members of our public that are listening tonight think twice before taking those extra steps.
Definitely. Have a great night, and thanks for joining us.
Welcome to Bar Talk. We're so glad you joined us tonight. We're going to be talking about orders of protection, what happens when there's a conflict of laws between two states like Illinois and Indiana, and what happens when roommates are not on the lease. So how are you ladies doing?
Doing really well, thank you.
Great. What's
Good to
new with
see
you?
you. Well, if you guys don't mind, I have something I really want to talk about because I feel like this ages me a little bit. So I don't want to tell you how old I am, but I will say I'm not Generation X, Y, or Z. Is that even real?
It's a thing.
Okay.
It's the Facebook generation.
Right, exactly. So what I have found in my family law practice is that orders of protection are looking a little bit different than they used to. Mm-hmm. So if you think of abuse, tell me what you generally think of.
Any abusive situation.
Physical abuse.
Yeah.
Exactly.
Emotional.
You think he punched me or he pushed me against the wall
Right.
and I need a court order.
Or internet harassment, I would say.
Well, that's new. I
Yeah.
never would have thought of that, except more and more commonly now, I'm getting a lot of questions about, you know, consistent texting or calling, you know, blowing up my phone at 2 a.m. And I think what we really need to understand is that generationally there's a shift.
Right.
You know what? That's a good point, because cyberbullying is a term of art that has been coming up.
Exactly.
Well, we talked about an order of protection before in a landlord-tenant situation, and I had a client, tenant, that was being harassed by the landlord, and I recommended an order of protection. And that was maybe the reason she didn't get it, is because it was landlord-tenant, and it was texting and calling and visiting the property, but it wasn't abuse.
Well, in a family relationship, and by family relationship, it means a variety of things. It can mean someone you used to live with, used to be married to, currently date, used to date. There's a variety of things that fall under the umbrella of family under the statute. But what's important to note is that harassment is a form of abuse. And I don't think a lot of people realize that.
Yeah.
So I had a man walk into my office and he was looking for representation. He says he was, you know, accused of abusing his ex-girlfriend. And when I asked him exactly what he did, He says that he sent a series of text messages telling her that he loved her. Now,
Abuse by love.
right, so hold the oohs and the ahs, because I don't think she really appreciated this attention.
Right.
As I asked more about the fact pattern, he explained that she broke up with him, and he didn't like the idea. And so he proceeded to text her, "I love you," 150 times.
In one day?
Quick succession. And she asked him to stop, and he didn't stop. So girlfriend proceeds to go to the police station with her phone, and not only does she file a report, the police officers look at the evidence in real time while he's sending these texts. And when I had to advise him about his legal options, I advised that when we go to court, his best course is to accept the 2-year order of protection to keep himself out of jail.
Well, you know, it comes back to respect other people. You know, no means no. When people tell you there are these limits,
They don't love you. Then
Right.
they don't love
you know,
you.
others have to respect those boundaries.
Right, and it's actually a form of violence when you don't.
So
I
is
think-
the First Amendment a defense to this? You can say you can have any form of communication you want, but if the other person doesn't wish to receive it in the mode that you are sending it, that's what's limited. I mean, the profession of love is in and of itself not illegal. And unrequited love is not in and of itself illegal. So at some point, it crosses the bridge to unwelcome.
maybe at, you know, the 97th text or the
But is
99th.
but that's the issue. Is the issue that he's harassing her by phone? Because, I mean, could she not turn her phone off?
Oh, but why would she have to go to that?
I'm just asking. I mean, there's a statute.
That shouldn't even be a consideration.
There's a federal statute that prohibits solicitors and advertisers from communicating to you unwanted and unsolicited advances. $500 per violation. There's no such similar statute yet in the family law context, but it's the same message. You're sending me something I don't want. It bugs me. It costs me money to print out. It's my text message bill. You know, I don't know. So what I'm hearing, the issue that isn't bothering me is the fact he loves her. It's the fact he's texting her an unwanted message that she's forced to receive and therefore deal with.
Correct.
But
In
the
which she
profession
asked
of
him
love
to
is.
stop.
But there's no law against that requires him to stop loving her. What you're saying is that's the issue.
We're talking about the communication of
Right,
that
right,
love.
right. And that's what I'm saying. I mean, that's what makes it interesting. If he's my client, I'm going to say, well, lay low, buddy. You know, like,
The
let her go.
problem is
But
he took it too far, right? And so the issue is you may have those feelings, but you don't have to act on them. You might have to find a different way to handle your emotions. But causing somebody emotional distress is against the law, and it has serious consequences.
So is the profession of love in that manner, did she get a restraining order?
Well, that's why we were in court
But
together.
Did it work?
It did work, because here's the other thing that happened, is as soon as he was served with the papers, he didn't stop. And being
Interesting,
served
okay.
with an order of protection means you are to seize
All
all
contact.
contact
Right.
with the individual. And the fact that he didn't means that he could have been placed in jail instantly.
Well, so then that obviously begs the question of a bigger problem that's going on with this gentleman. And, you know, hopefully that will be dealt with appropriately. But yeah, somebody who's not going to abide by a court order, who's not going to respect that boundary that's laid, that I think that gives rise appropriately to judicial intervention.
But I think there's a lot of example in today's times, and that's why I think, you know, I think about what it means for our generation. You hear about the stories about revenge porn, about internet trolling,
Right.
where people
Yeah.
are trying to incite negative emotion in other people for the goal of harming them.
Well, ladies, this is good stuff, and I love you both. We're going to break.
I love you,
Thank
I
you.
love you, I love you, I love you.
Welcome back. We're going to talk about where intersection of Indiana and Illinois come into your life and how you deal with that. So ladies, I have an issue to propose to you because I'd like to know what you think. We live so close to the Indiana border, and as you know, Indiana has its own body of law, and we have our own body, and sometimes those laws do conflict with each other. So let me give you an example. Let's say you get into a car accident in Indiana, and you are an Illinois resident, and so the lawsuit would be properly filed in Indiana.
Who's suing who? You're suing.
Well,
you're
you get into a car accident because someone hit you, and so
You
you're
sue
going
them,
to
okay.
sue them.
Okay.
But since you're the Illinois resident, but the car accident happened in Indiana, you're going to sue there. And as a result of this car accident, you are so severely injured that you need a guardian in place because you did not put your estate plan in order. You know, these are unexpected circumstances. Let's say, you know,
They didn't call you first.
Right. Many younger people don't have their estate plans in order. So this could happen to anybody. You get into this car accident, you have injuries, now you need a guardian in Illinois because you're unable to manage your affairs. You have this pending lawsuit in Indiana. You hire Indiana counsel to go forward with this lawsuit. Your Illinois matter is a guardianship matter because you want someone to be able to manage your funds. So the Illinois court has basically control over your money. You know, the Illinois judge is going to decide what is going to get paid and what isn't.
But isn't this really complicated? Because essentially you're the same person, even though you have these two separate matters in two different states. How does that work? Are they happening at the same time?
Well, I mean, they could be going on at the same time, because if you get into a car accident and you need your guardian appointed right away because you need to have your bills paid and you still have obligations to meet, you're going to go get that guardian. Someone in your family or in your circle is going to get that guardianship in place to protect you. But that same person might pursue this lawsuit on your behalf in Indiana as well, because you have the person's insurance information. You want to get this suit going as well, as part of.
So this is assuming that the insurance company is not handling the case on your behalf, and you've brought a private suit against the Indiana person.
Right,
Okay.
and so my question is how you have an Indiana attorney that you've hired who is expecting to get paid out of this lawsuit. That's common, a contingency fee arrangement. But the thing is, the Illinois judge is the one that controls your funds.
Right. So the way that I would approach it from a litigator's perspective is that the case would have to resolve itself in Indiana, and then once the attorney is entitled to payment from whatever the result of the lawsuit is, they would have to file a motion in the Illinois court for permission to be paid.
Okay, so
or conversely, the
step.
guardian would well, the other thing is that the Indiana lawyer would send the bill to the estate or to the guardian.
So let's take
and then the guardian could apply to the Illinois court and say, I need permission to pay this.
So let me just take it the next step is where the Illinois judge says, I'm not paying that bill.
Right.
You see how high that is?
What if in Indiana a third is customary and in Illinois it's
there's
not?
a cap, and in fact that is the case.
But
There
the judge-
is a cap in Illinois where there isn't in Indiana through the probate division.
But the judge is obligated to apply state law in relation to the formation of a contract. So then what the judge is to do is to interpret the contingency fee legal agreement, and generally speaking, that agreement would be subject to Indiana law. So even though a court in Illinois is sitting in Illinois, they are empowered to decide under Illinois or Indiana law what the answer to the question is. So
they might say it's against public policy for Illinois.
They
and it's unconscionable.
They wouldn't have the right to do that because the judges that sit in every state have the power to interpret other states' law, this issue is called choice of law provisions and conflict of law provisions. So as a result,
but that's typically in contract. And
a retainer agreement is contract.
No, but in this proceeding in Illinois, we have a guardianship matter, which is pursuant to the Probate Act.
You're right,
because spending the funds of the estate needs to be approved by the court.
You're right, but at the same time, the decision to hire the Indiana attorney was done through approval of the guardian. Once the guardian is appointed, they're not in court every day. They are in court when matters necessitate.
No, in this hypothetical, you have two things that happened at the same time, but the guardianship was not part of the contract.
Of course.
Yeah. So you don't have the guardian having approval to enter into the contract, because then I could see where you're going.
But the guardian may not need approval. The guardian's charge is usually to act in the best interests of their ward, whatever those might be. So in theory, the hiring of an attorney out of state is not, by definition, against the interest, because they're pursuing the interest of the ward. So I would say, my opinion is that the guardian could apply to the Illinois judge, or the lawyer could apply to the Illinois judge. If the answer is no, that creates a right of appeal, and then the decision would trickle up through the legal system as to what law would apply. Does the judge have discretion?
So should the law apply in Illinois because it's in the best interest of the ward? Or should the law apply in Indiana where the contract was made?
I think the law,
What do you
personally,
think?
I think it has to be respect for the Indiana law.
And I would say Illinois. I mean, this is where the estate lies. This is where the funds are coming from. This is ultimately where we hope he will end up once he heals from his injuries and returns
Yeah,
home.
well, he's an Illinois resident. Well, thanks, ladies, for your thoughts. We're going to go to break.
Thank you.
Thanks for coming back. Our next topic is if you have roommates, but they're not on the lease. What happens if there's a problem? And Elisa, what are you going to inform us about tonight?
Well, I think it relates to a recent situation that came into my office, and the tenant, who was my client, had a lease with a landlord, and then she had a successive series of roommates, and then ultimately the landlord sued her for eviction. And so her question was, can I be liable for the whole rent? So I explained to her that when a person, an individual person, rents an apartment, that apartment is one entity. It's the property. So when the landlord seeks to recover the rent for the property, the landlord is going to recover the whole of whatever is due to them, and it doesn't matter how many people privately agree to share that space. So in her situation, with the number of roommates that she had, one after the other, her concern was, well, why should I be liable for my roommate's portion of the rent? And I said, well, if the roommate was never on the lease, then the landlord is entitled to recover rent from anybody that was there or anybody that he has a contract with. And I said, if you wanted to protect yourself, you should have had a private side agreement in writing with the roommate,
Okay, but
splitting
I
that
think
There's a little
obligation.
bit of an issue with, does this relate to the concept of privity, where the landlord is able to go after the person on the lease for rent because they're in privity of contract, but they're also able to go after other roommates because they're in privity of possession?
And
Is
before
that-
you answer, I have one more. What about joint and severally liable? I mean, what if both people's names are on the lease and one stops paying? Can he go after the other for the entire rent?
Yes. So both of your questions, the answer is yes. It relates to privity. So the privity is the concept of the chain of contract. Whoever the landlord has a contract with is the first party against whom he can find recourse and liability. But if there's a roommate there and they're soaking up a portion of the property by virtue of possession, then the landlord has recourse against them. Maybe not for contract damages, but he can get what's called use and occupancy during an eviction case from whoever is there. So that's where privity comes in.
So is this a percentage, or is it by default everybody here has joint and several liability to the extent of reasonable rent?
Joint and several liability is a contract concept which relates to if you sign a contract. If I sign a contract with the two of you for renting my apartment on Green Street, each of you could be liable for the whole. So if the rent is $17,000 a year and I come up with $15,000 of back rent that I'm saying you owe, I can sue you both each for the $15,000. I don't care who I collect it from. And I could get a judgment against both of you for the full 15 to you and 15 to you. Now I can't collect double, but I can enforce. In theory, it looks like I'm enforcing doubly. So that's where joint and several liability comes in. It's just, it's something that the law has created by contract.
But without the contract, she rents from you on the lease, I'm there as a roommate, can you come after me for the whole amount of the lease?
I can go after her for the whole amount of the lease, and then she can sue you for your 50%.
And if I don't pay, then I'm out.
But you can,
Right.
you can also come after me
For possession.
only.
I can come after you for, if you're the roommate that's undocumented, I can come after you for possession. And then if say you're fighting the eviction for some reason or you're just not moving out, I can get a court order that says you have to pay a reasonable value for your possession on my property.
What about past possession? Could you come after me for my past possession, getting
No.
a reasonable rent?
No, the use and occupancy happens during the pendency of the case. So if I have been in an eviction case, I'm the landlord, and I don't get use and occupancy during the pendency of the proceedings, then I'm out of the box on that. But I can get an eviction order against you as the tenant. So, you know, where I was talking about with this particular individual, I was saying if it matters to you, get it in writing. And that writing extends to not only the relationship with the landlord, but amongst the tenants themselves.
But real quick, are you allowed to just have a roommate come live with you without their name being on the lease?
I think that I get that question all of the time. I have a lot of landlords. I probably get one call a week about this. And people will say, well, I didn't say they could have a roommate. And I'm like, well, how many bedrooms are in the apartment? Well, sometimes there's 3. Well, if you rent a 3-bedroom apartment to a single individual, you're not telling them, unless you specifically agree with them that they can't have roommates, there's nothing preventing them legally. I wouldn't say it's a breach of the contract. I think it's, in many cases, it's understood. So if a landlord has a desire to limit the number of individuals or adults on the premises, they need to put it in writing.
But is there some other consideration with limiting the number of people?
Well, it's a fire code. I mean, there's under certain municipal and building regulations, there's a certain number of people per bedroom.
Okay, but short of that sort of municipal regulation, a landlord doesn't have to be concerned with other reasons to limit the number of people
Well,
inside?
you don't want criminals coming and living in your
No,
apartment.
I just mean the number of people.
No, I mean, again, it is, it's a matter of contract. There
So
isn't.
can a landlord say, I only want to rent to 2 people even though I have a 3-bedroom
absolutely.
house?
I've seen leases like that.
Certainly. But if you have a 3-bedroom house and you rent to an individual person who later gets roommates, that could create a gray area. But again, if you rent to 2 people in a 3-bedroom house and then they have a child, third person is created later, you know, it comes up.
Well, you put it in the lease, no children allowed.
Can't do that. Can't do that. I've had people try, believe me.
Oh, no.
But anyway, it's a matter of contract, and to the degree that if there's a foreseeable problem that the landlord anticipates and wants to prevent, they can try to make that agreement.
Okay, well, thanks for that information. Sounds like it can get pretty complicated quickly. Call Elisa if you have any questions. We're going to break.
Okay, let's do this.
Thanks for joining us. We have a special guest tonight. He's the executive producer of this show, and his name is Stephen Patterson. Thanks for joining us, Stephen.
Welcome, Stephen.
Welcome to the table.
Well, thank y'all.
We're glad to have you here.
Well, I'm glad to actually be here with all of you lovely ladies. And I just want to start off by actually saying I hardly ever get in the front of the camera. And this is just one of those times that I thought I needed to.
Well, we're putting you in the hot seat tonight.
Yeah. So y'all get to bombard me and make me feel like I'm at
Well,
court.
there's been some rumors, and we would like to know the scoop. I think there's some news going around the hallways here.
Yeah, well, Can TV on Green Street will be closing. We will be closing this facility, and we will be opening up a new facility.
I was just going to say, and we're all out of a job. And we'll be ending this show in 9.
And we're actually building a new facility that's in the process right now. It's supposed to be finished
Any minute.
Gotcha. Perfect. But you know how those things go in Chicago. So I thought it would be very important that we tell our viewers and how this might impact not just our program, but all of the programming that you see on Channel 19, on Channel 21, on Channel 36 over the next couple of months. And the reason why I say that is because this facility closes the beginning of September. The new facility, we're supposed to be in it and actually gearing up to do shows at that same time, and there might be a lag time in between.
If you need a good construction and real estate lawyer, you just call me.
Oh, right. Well, yeah.
I can make it happen.
What I'm
imagine
thinking
the transition
is the transition might be challenging, but this is actually really exciting news.
Yeah, it is. Brand new facility, you know.
And the facility is built around our needs here at the studio. Because we came into this building and made adjustments to it for us, but this new facility is designed.
Exactly.
That's fantastic
for the studio, and it's only the studio. We're not sharing space with other people in the building. It's only a TV studio, so therefore the functionality should be a lot better. And I, do say should be, because whenever you get something new, you got to work the bugs out.
Well, Stephen, tell me a little bit about Can TV. I've always wondered, who produces these shows? What is your community like? Give us a little bit of insight as to what goes on at Can TV.
We need like 6 shows to go through that. Basically, Can TV is a nonprofit organization that was formed for the basic principle of allowing the city of Chicago to have a community voice on TV.
And isn't it true that anyone can produce a TV show here?
Not anyone. There's a couple of caveats. One, you have to either be a resident of Chicago or you need to be a nonprofit that is out of Chicago. Either one of those two, and that creates a lot of different things that actually happen. Even though you could be out of the state, out of the country, and submit stuff, you would need a sponsor that's up under one of those two umbrellas.
But so if you live in the city of Chicago, anybody is allowed to come in and avail themselves of the production facilities and the studio time if they reserve it.
Correct.
That's great.
But let me caveat that one. You have to be certified, so you just can't show up and say,
Okay.
hey, I want to do a show today. It doesn't work that way.
They're not going to let any stranger handle your cameras.
No. It's a process that you got to go through. And then if you want a regular show like ours is, where it'll be a weekly show, you have a lot of more steps that you got to do to prove that you're able to do enough shows to keep up with a schedule, because people start wondering about, why didn't this show come on this week?
Right.
That's because those shows wasn't proven. So
And how long has CAN TV been in existence?
Ooh, now you got one that I don't actually remember. Let's see, I started in 94. So 4 years before that. I'm not sure. I would say it was the late 80s, beginning 90s, because I started in 94, and I know it was at least 4 years before then. But I've did almost 500 productions here, so therefore it's probably I'm like in the top percentile as far as producers around here.
That's great. Now, are
So we
there
landed with the-
opportunities for local artists and producers and different people in the creative field to have chances to meet up and to do different events that are surrounded by, the facility or the resources here?
You got a little bit of everything. You got TV programming that's geared strictly to an ethnicity group, like maybe a Polish group that actually has programming.
Yeah, actually, we have a Serbian community. I'm Serbian, as you know, and we have a strong Serbian community, and one of the producers here does Serbian TV.
Nice.
See, that's a perfect example. As well as you got what's like Hotline 21, which is, how can I say it? It's like studio in a box. Rather than having all of the camera people and all of the people that need for a production, you basically are nonprofit organizations where they come, they train you on one day for about 4 hours, where you learn to just sit down, press one button, and you're literally on the air. You press another button to answer the phone when people are calling in, and that's how the show goes.
Oh, that's great.
Interesting.
So will the viewers be able to tell when we move to the new facility? Will they be able to see any difference coming through their TV screen?
Oh, yeah.
Okay.
The quality of show, and of course, being a new facility, it's just a lot of updating of camera equipment and things of that
Okay, so
sort.
some of the technology that's
Yeah.
coming in is going to replace our current
Correct.
technology, and so they are going to be able to get the benefit of that.
Correct.
Oh, that's
Excellent.
great.
That's very exciting.
Like I said, that's the only reason I wanted to come here, because I'm scared of y'all, actually. I mean, it's some of the topics that y'all hit, and y'all just going for it, and y'all literally scare me to death.
Who
Lawyers
runs
do
CAN
not need
TV?
to be
Is it
scary.
run by a board of people, or is
Yes.
there is there a general manager of the studio? I mean, what is the structure of the management?
You have an executive director, you have program director. It's a full-blown 501c3. It's at least 20 staff members here.
But as far as the management of it, is that done by a board of directors, or is that done by the executive
It's
director?
done by the executive director that's actually following the executive orders from the board. type of
Okay.
deal. So that's the separation of the two.
That's great.
And CAN TV has a website, I know.
Yeah.
And one of the things I noticed recently was that they started uploading
TV show.
TV shows, which is really great, because that also, my understanding is that it's a new development.
Yes, they just started doing that the beginning of this year, and as shows develop, they're starting to upload other shows. Of course, the goal is for all of the TV shows that you can pull off of the web.
Well,
But-
that you just jumped to my next question. I was going to ask, did you know if all of our shows will be available on the website eventually?
Eventually, that will take some time, because we have over 700 producers here. and 4 different channels. So I don't know.
It's a lot of programming.
Once we get in the mix,
Exactly.
we'll be on.
Exactly.
But I think that's great, because even if you're not available to watch our show when it airs, hopefully you'd be able to find it online.
And actually, as the producer of this show, one of the things is as we go over into the other facility, and I've mentioned to y'all personally, but can mention to our audience and viewers, that we will be developing our own website that you can actually go to, as well as our Facebook page where they can get what's called drip feeding of the show. We're now put full shows on there, but they can get segment by segment. And then all of y'all's websites, that way you can link it to your
Excellent.
websites. And
it'll be a nice little cobweb
That's
of
right.
bar talk that you can get stuck in.
Exactly. And then you can get more information about each one of the topics, because that's why we have the topics the way we have them. It's so that they can then bridge off into separate topics that talks about specific areas of law.
Excellent.
So, y'all kept bombarding me. Can y'all wrap up, please? I mean,
Did you
I'm
survive,
scared.
Stephan? Are
I'm
you
really
okay?
scared of y'all,
Well,
you know?
thanks, Stephan, for joining us at the table. We're really glad to hear this great news, and we're excited about the transition.
Okay. Well, like I said, I'm looking forward to more shows, and catch us on Facebook as well.
Thank you.
Thanks, Stephan, for joining us tonight. That was a lot of great information, and we're really excited about this transition. We hope you enjoyed the show tonight. Like Stephan said, you can visit our website. You will find us on Facebook or follow us on Twitter. We look forward to hearing from you. Have a good night.